Hi, how's it
Hi.
going?
Good. Happy Monday.
Happy
Happy
Monday.
Monday. Sophie, are you back in our time zone now?
I'm back. I'm back in Brooklyn. I solidified my apartment for next year. I'm feeling great.
Good stuff.
Yeah.
I'm sure I've asked this before, but what part of Brooklyn are you in?
Right now I'm in Bed-Stuy, but I am relocating to Prospect Heights in June.
Okay, cool.
So if
Uh,
there are any neighbors in the cohort, let me know. We'll grab coffee.
um, yeah, we'll do. Although we should take advantage of while you're still in Bed-Stuy, I'm in Bushwick, so much closer for us to get a coffee or something.
Definitely. Let's do it.
I'm in Connecticut for about 3 more weeks.
Well, I used to live in Boston, so that's not so far off.
I'm moving to Virginia,
Oh, cool.
just
What
outside
part?
DC,
Alexandria or
about 20 miles south.
cool. Nice.
Yeah,
Where in Connecticut are you leaving, Brian?
Norwalk.
Ah, it'll be sad to miss you. I'm literally in Stamford right now.
Oh, I lived in Stamford for 7, 8 years.
Nice.
Yeah, um, got a daughter, and I think DC area, DC Metro is actually a better place for us business wise anyway. So uh,
Cool.
Yeah.
needed more space than Connecticut wanted to give us.
That's fair.
So we might have a few more people joining us here, I think. But figure we can start getting things kicked off.
Sure.
You had a chance to meet Jack a little bit earlier. I'll just, but and have him reintroduce himself for the one or two of you who were not at our kickoff session. But glad we've got a couple more people here. Also wanted to just briefly share that there'll be a this repeated again, but this is going to be an interactive session and with some polling questions. If you want to get started, the QR code in the bottom of the screen there will get you started if you wanted to like take a picture of it with your phone. And yeah, otherwise I think I will stop sharing so that Sham can bring up the actual presentation, and then I'll or do you want to start, Jack, before we like bring that up with
Sure.
yeah.
Yeah, I can chat for by myself with myself, the royal we or I, for a minute while we get settled, and then I think once we switch, it'll go to the polling platform, right, Chum? So we would lose the QR code once we switch.
No,
No,
the
it's going
QR
to be on
code
the
is in the
first
Oh,
first.
great.
slide.
Okay.
Yeah.
Okay. Cool. Cool. Even better then. Yeah. So hi to those of you whom I see.
Sorry, Jack, I apologize. Reed, can you stop sharing?
Yeah.
Thanks. Sorry, go ahead, Jack.
Okay. No problem. So yeah, to Reed's point, this is intended to be an interactive presentation. So please do pay attention. I usually do these in person, so I like, jump at people and attack them if they look like they're not paying attention. So please do. And I say that by way of saying, one, it'll be better if everyone's responding and engaged. So it'll actually be more interesting if you guys are focused. But also, you'll get more out of it if you are. And the whole point here is we want to do something valuable for you guys and with you guys, which is why we've started doing this presentation in this format. So just a couple of minutes of an intro, and the premise here. So I do this is sort of like a high level 101 of early stage pitfalls kind of thing. We try to do a broad brush of a lot of different areas that almost every startup will touch. And in 17, 18 years of practice, I've seen just about everything, including a lot of horror stories and things that go wrong very quickly that aren't necessarily intuitive. So a little bit of it is trying to help with that. If hopefully you come away with at least a little bit of nuggets of wisdom from this presentation, and it's really intended to just sort of be a course to say, things you can learn from, including things you actually learned, but then also things you just, you might not learn here, but you might learn the next time around. So the name of the seminar is Raising and Passing the Bar. And so that's supposed to be sort of tongue in cheek and funny, but I wrote it, so I think that is, so I'm biased. I am seeing smiles, so that's good. Some people are paying attention. These questions, a lot of them are written. So we're going to polling questions. We're not going to have any slides. Slides are dry and stale and boring. So it's just going to be 10 super fun, super interactive polling questions. And we're going to talk for an hour based on those questions. And the way they're set up is some of them are set up similar to the way the bar exam is done, which is, I know, super fun for everyone who's ever heard of that. In that sometimes there's one right answer and the rest are wrong. Sometimes they're all somewhat right but kind of wrong. Sometimes they're all somewhat wrong and kind of right, and you're asked to pick the best wrong answer or the least bad answer, sort of thing. So it's not all super black and white here. And so, oh good, the QR code is there. But really, really important that you all respond to each of the questions, and it's anonymous. So not only are there no wrong answers, no one will be able to know if you gave the wrong answer if there were one. So again, obviously we want people to interact. And so I'll just sort of dive in. Okay, so I see 7 responses so far. So this is our test, right, to see how many people are here. And no one is afraid of answering this question. This is topical, right? These change every time. The question here today to kick us off, April showers bring Mayflowers, but what do Mayflowers bring? Okay, 8 answers, good. Birds and bees, very nice. Oh, good. An uptick in allergies. I put allergies. I think allergy season is really bad right now, particularly this year compared to prior years. June bugs and pilgrims, of course, right? So the old joke of maybe a couple smiles. Great. So
I'm definitely voting for dad joke.
Yeah, dad joke, right? Yeah, you can take the dad out of the house, but he's still going to make the same dad joke. So I apologize for not being able to change my stripe. So, okay, we've got 9 answers. Great.
Sorry.
No, you're good. You're good. Okay, so the test looks like it's 9. We want to make sure we get at least 9 answers, or I guess all 9 answers as we go. So as we do this, we'll go through, and hopefully, everybody will be responding. But that first one is just sort of to make sure everybody's here. Okay, so again, no wrong. Everybody should be answering these. So the first question here, and again, sort of a wide range of topics. When is the right time to engage a startup lawyer? This is a question for everybody. So the first answer, when I have enough money to submit a $10,000 or more retainer deposit. B is when a problem arises with a co-founder, investor, employee, consultant, or a contract. C, when I've signed a term sheet to raise money from investors or enter into a strategic arrangement. Or D, ASAP, even before I formed my company, if possible. Good, so we've already got 8 answers, which is really good. Now, so looks like everyone's doing a great job here so far. So I'm actually glad that looks by my rough math that 2 people picked the first choice, because that's very much a common thought or stigma or concern. Fortunately, it's very wrong. So I'm sorry if I just told you that you're the 2 people that chose the wrong answer, but the good news here is that a startup lawyer and a good startup lawyer will know that you're just starting out, you're probably bootstrapping, cash is tight and critical. We're trying to think of all sorts of ways that we can come up with cost savings and all these sorts of things. So the idea that it would be is sort of counterintuitive to the startup world. Now, not to say that there aren't, costs and expenses and things that you will occur pretty quickly early on. But I don't think the startup world works if A were the answer. So all by way of saying, if you have questions or concerns, or you're starting a business, all good. Jane, all good. And you understand you don't have a ton of money right away, but you have legal questions. You want to find a way to thread the needle here to be able to work with someone, so you're not just guessing and doing whatever you can on your own because you don't think you can afford it, right? So I just want to take a minute on each of these. So a good startup lawyer will find ways to work with you, particularly if you are just getting started or don't have a lot of runway and all that sort of stuff. B is very much so 0% said B. We get B all the time, including from former Founder Institute cohorts. People that have come to us with this issue after not working with us before. As lawyers, as practitioners, we can only do so much in arrears, I would say. So if there's already an issue, or there's already a bad contract, or there's already a problem, or there's already a tax issue, we can do certain things, but a lot of times we can only do so much. And so the whole point of a good startup lawyer is being proactive in advance, working through things before things go wrong, right? So that's B. Even though no one put it, we actually get that all the time. C, I want to talk about too. I'm also glad nobody put this, but I want to talk about this for a minute for a couple of reasons here. One is that if you've already signed a term sheet, you've lost the value of so much of what a good startup lawyer can help you with, which is high-level strategy and negotiation and discussion, whether terms are market, doing a little bit of research on the investor, whether you're going out for a lead or just a larger general round, right? Like so many different, what type of security you're going to do when you're offering. So there's so many things on the early stage that really should be discussed with a lawyer before even looking at a term sheet, let alone signing one. And the other thing on that is, a lot of times these term sheets will say, it's non-binding, or non-binding except for, exclusivity or confidentiality, or a couple of little things. So that's kind of true, but sort of the dispelling the myth on that. One is there is a duty to negotiate in good faith, even on non-binding term sheets. So if you just totally disregarded something and said, actually, just kidding, I don't want to do this. We have seen places where people have sued each other over non-binding term sheets because they just blatantly disregarded the duty to negotiate in good faith on a non-binding term sheet. And also, the terms of a deal in a term sheet, even if non-binding, will drive, those are the business terms, with some legal terms folded into the term sheet. The first time you go back as company side and say, actually, I want to change this because now I have a lawyer and I figured it out, or whatever reason, that's retrading. A lot of times investors will just walk away or yell at you, or both. And maybe the best case scenario is they listen to your attempt to change something, but then ask for something back in return. So, a lot of times you're not just going to get and by the way, saying, oops, I didn't have a lawyer when I signed this term sheet is not what the investor wants to hear either. That's not great. So all the more reason, and again, I know nobody here picked C. We've had people that do C. It's, sort of the bane of our existence, and creates a lot of huge problems. And then one thing, I am seeing some comments in the chat, which is great. We only have an hour, so we'll try to get to as many as we can. I want to be sensitive to people's time, so I will try to address some of them at various points. Oh, if you could go back, Sean. Sorry. But we'll just try to go as much as we can. But do feel free to put them in there, because we want to memorialize, questions, and it's a good place to put them. So thank you for the comments. And D, even before I formed my company, ASAP, yeah, is this a shameless plug for lawyers who want you to do stuff? Maybe, but really it's, some instances, where am I domiciled? Am I going to be a C Corp, right? That's the less of a question for you guys, but so many things are pre-formation that you can get advice from a lawyer on, that you can really get value from. So I just want to mention that. and then really quick before we go to the next slide, there's one question: at what point is the retainer expensive? So because this is the only page where we are, I think, going to talk about retainers and stuff like that. What exactly do you mean by that for that question?
Javier, are you there?
Oh, might have dropped. In any case, so um,
Oh, sorry, hold on. She just got looks like she dropped and then came back. So she should be here in a second.
okay.
Okay.
I'm sorry, I was just trying to switch to my phone. I just saw that you had a clarification on my questions.
Well, I was just asking, yeah. So, what exactly do you mean? At what point is the retainer expensive? What exactly was your question for that?
Yeah, sorry, I should have clarified. So where I was going with is when I try to set up my C Corp, LLC, try to decide which one I should have at this point, and try to get the legal documents like my privacy policy and all of that validated, I got like shockingly high retainer numbers. And this is based on like zero prior experience. And I was like, is this what startup founders are giving lawyers before they even like have got any dollar in or raised any money? This was 5K plus. And some of the expensive ones asked for 10K. And these are all based on like people I just search off the internet. So
Sure.
I was like, I couldn't find other people at the similar stage. I was like, what is good? What point is this like expensive? What point do they deserve a 5K retainer? Like what sort of services or package should we expect? I just don't know what normal looks like in this market.
Yeah, for sure. So thanks for clarifying, and I do want to spend a minute on it. So and then Giovanni, we could talk about some of that stuff separately offline, but also a good question. So look, our firm's standard retainer policy for a new client that doesn't have a historical track record is a minimum of a $5,000 retainer generally. That we then, if it's someone from a known referral source like Founder Institute, we go for approval for an exception for that. So, for the case of this, if you do our formation package, the retainer amount up front is the filing fees, which are out-of-pocket costs that we incur, right? So that's a pass-through cost, and the small fee that's just the formation package for Founder Institute people. We don't ask for anything more than that, because we're going to do that much work in the first 2 weeks, right? But that's also, we work with startups and do all the time. A lot of times when you see a high retainer like that, either they don't really work with startups, or they only work with startups that are so maybe well funded that it's, that they're, they want to have that sort of financial implications with it. But probably for the best that one didn't end up working out, right? And you should always, and every firm's going to have a different policy and a different thought on this, so definitely ask around, get a few opinions. But thank you for the question. Okay.
Thank you.
All right, we can go to the next slide. All right, great. So another question to this similar topic. Okay, no, these are super, super small, so I'll have to get on my bifocals. What's the best way to work efficiently with a startup lawyer and minimize costs early on? So this will speak to sort of the question of, super expensive really quickly. If it's really small for you guys, don't engage with a lawyer until I've raised money from outside investors. B is only talk to a lawyer about a few specific discrete topics that I think are important, I being the founder. C, do as much work as I can, relying on AI searches and finding my own forms as starting points. And D is tell the lawyer everything at the beginning, make sure I fully understand everything, and decide on all key terms before the lawyer starts drafting and negotiating. So I'll give you guys a minute on this one. Okay, good. We've got sort of, I'll call it a critical mass once we get to 7 being a magic number. Oh, and 8. Great, Jane. Yeah, thanks. So, okay, so we have one for don't engage until I've raised money from outside investors. So, I think we tried to speak to dispelling that myth at the term sheet stage and said make sure that's, that you are working with somebody before then. So, look, if it is, we can help and figure it out. But you definitely don't you definitely want to engage with a lawyer before then, if only because if you're raising money from outside investors on an equitable security, you are working in the securities law world, and there are a lot of things that you can trip up inadvertently without realizing. So if you have done that, call a lawyer immediately. B, nobody picked B, but I actually I get this a lot. I get hey, I don't want to run the clock. I don't want to overcome. I only want to talk about the things that I think are important. Hey, I know I've got an employee, or I know I'm going to need a trademark, but I'm only going to talk about these few things because I don't want to spend too much time. That's actually not, and nobody picked it, so I won't spend too much time on it. But the key is your startup is a puzzle. A lot of different pieces to what's going on, a lot of different pieces that you don't necessarily know all the legal consequences and ramifications of. It's important to tell the lawyer everything about you, about your business, about your co-founder, about your potential customer base, about your exit strategy, about how long you want to do this, about what you were doing before this, about where you're located, the full picture, right? It's and once you've engaged, it's all privileged and confidential. It's all helpful to the lawyer to see and hear all of your information. The only thing, there might be one other, but the only thing you really shouldn't tell me is where you hid the body of the person that you murdered. Because if you did that, good, I am seeing a couple smiles. If you murdered someone and hid the body somewhere, I cannot keep that confidential. I have to call the police. And also, you should not have done that, right? So I'm not going to feel bad that I have to rat you out. Anything else, including like my co-founder's an alcoholic, and I think he's cheating on his wife, and so I'm nervous that, right? I'm nervous that my co-founder might be a flight risk or might not carry his or her weight because of some social things that I've seen that are troubling me, even though they've got the connections and they're brilliant or whatever. You should share that. Right, maybe like all the things about what's going to happen with your business and what you're concerned about and what you want to do and how and why. You want to share everything, and then we go, okay, well, we can structure things. We've seen that story before. Here's what worked in a different example. So definitely overshare. Yes,
Just both of those. One, a co-founder who was an alcoholic who had to go into rehab and ruined a deal was something I worked on, and another one where the CEO was sleeping with one of his employees and wrecked, like, we had a full agreement like ready to be signed and got blown up on the last day because of that. So I've seen both of those.
great, and letting everyone know this was not rehearsed, and I had no idea. So corroborating that these are real situations, right? So C, we are getting more and more of, and I think Jane, I think, admitted that she was a C on this one. Look, as a startup, as a founder, you have to be quick to come up with the answers, and you have to be creative, and you have to come up with solutions to things. And a lot of time people nowadays especially are using, AI and Google research and all these things to try to figure out answers on your own. To a point, right? Like there's certain things you want to research, but you really do want to rely on your legal counsel for teaching you and advising you of what the issues are. Don't try to do too much. You'll spin yourself in circles and go down rabbit holes you don't need to go down. Your lawyer should be helpful for that. And with documents, I will say that 10 times out of 10, maybe 11 times out of 10, when you have a document that you found online, pulled from a whatever, and then you provide it, well, often it's not right. Then it's actually harder to like rework that document into what you need. A lot of times it's better to start with the lawyer's forms, which cost $0 because they have forms that sit in our database. So as much as you might think you're helping by providing a form of operating agreement or a customer contract or something, a lot of times you should just rely on the lawyer's expertise. It's more efficient, like I said, 11 times out of 10 when you just let the lawyer do the work. right? I understand there's, this natural tendency to want to cut corners or help, but you actually let the lawyer lead is the most efficient. Do we have a cheat sheet for all things we consider talking about, lawyer? Blah, blah, blah. Thanks, Sophie, for the shameless plug. Yes, we do. So we have a like a collateral piece with a startup kit, our Wiggin X startup kit. It's maybe 7 or 8 pages long, but it's a checklist of all the topics, right? And it's going to hit on almost all of these topics too, I think, which we can send around after the meeting. But again, right, like let us show you, or let us tell you what the whole syllabus is for the course, which is being a startup from the legal perspective, not you guessing, which chapter is which or whatever. So, yeah, no, you're very welcome. Great. Oh, and the last point on 7, which is here actually the right answer. The tell the lawyer everything we talked about. The key thing in trying to be efficient is to really make sure it's the deal, whether it's your founder relationship, whether it's an equity plan, whether it's a term sheet, whether it's a contract, whether it's anything. You want to have it really, really clear and crystallized what all the business points are, what the important legal points are that are explained to you before someone starts drafting. So if we draft something and then you realize a couple days later, actually, I want to change something, that's where it becomes 1.5x, 2x, 2.5x as we have to redraft and redraft, right? Really coming with a crystal clear plan once and then not changing it is the most efficient way to do corporate projects, transactional projects. Great. All right, so we can go to the next one. Okay, what type of entity should I use for my startup and why? Now, again, I apologize that these are like written for ants in the answers here. I think they need to be at least 3 times larger. So Delaware C Corp, because I was told investors only invest in Delaware C Corps. Nevada C Corp, because that's what Elon Musk said recently, with the little Elon. C Corp, because my business should qualify for qualified small business stock treatment upon sale, and I want to start the clock now. Or D, whatever my lawyer and accountant tell me to do. Great, so 9 answers. So poor Elon, tear, right? I will say though, I mean, it was like 2 months ago and we're writing a blog about the reaction to this. He got all mad about Delaware courts because he got sued and lost a derivative lawsuit in Delaware with one of his entities. He's now trying to send people to Nevada, which claims to be a competitor to Delaware. I'm glad we're not just going up based on Elon's sound bites here. So good work there. So
Wait, just on that, Jack.
yeah, sure.
So I do think there's a little bit of bias of knowing what answers you and I want, right? So in the chat, 2 people already mentioned that they had considered Wyoming, and somebody did incorporate an S Corp in Wyoming. And Texas is in the news today. So even though nobody picked Elon in Nevada, right, maybe we should address that.
Yeah, for sure. No, and thank you, Sean. We certainly will in this slide, and that's good. Very fair and good to point out. So,
sorry to interrupt you, Jack.
Yeah, no problem.
Actually I incorporated in Wyoming, and I was under the impression, because we're a blockchain real estate company, that Wyoming gave us more protection for real estate assets. That's what I was under the impression of, and that's why I was convinced that Wyoming was the best choice.
Cool. So thank you for sharing.
Jack, can I say something?
Yeah, of course.
Sorry, my name is Williams. I own founder of StrataLink. We're into digital advertising. So when I incorporated my company, I live in California, and I noticed one problem with California. If you incorporate outside California and you want to open your bank accounts, you still have to incorporate in California too, as an outside country. So what I did at this stage, I incorporated in California as a C Corp. Is that a problem? Do I still have to go to Delaware?
Okay, so many things to unpack very quickly here for many different people with many different comments, which I'm very excited and happy to do. Nice, Jane, good one. And thank you all for all the questions. And I know I said don't ask questions, and now you have, and I'm smiling, so I'm just a hypocrite or whatever. But so let's go little by little. Generally, and not specific to Founder Institute, but generally, the most important answer is to have a narrative that makes sense to you, that you have talked through and thought through and worked through, hopefully with a lawyer who can advise and walk through these things. The reason I don't love D, even though it's not wrong and it shows, I guess, obedience or something, is because I don't want anyone to just say, oh, they said this, I'm going to do it because I said so. I'm not a because I said so kind of person. I'm not like that with my kids. Maybe that's why they ask too many questions now. But it's important to understand what you're doing and why. If for no other reason, then someday you're going to have coffee with an investor and they're going to say, why did you do this? And because someone said so is not a sophisticated, impressive answer. Whereas if you gave an answer that was how you thought through it and worked through it and understood it, it would be much more impressive for something like this, which is, so all by way of saying it's important to think through and talk through as a general comment. So that's one thing. On Wyoming real estate protections, I have absolutely no idea, but my commercial real estate partner down the hall would. And so I would talk to Dimitri and say, hey, do you know anything about this in the conversation? And we would talk about it, right? And by the way, I run our group and I don't know the answer to that question, and I'm not embarrassed to say that. We'd bring in a specialist for your industry to see whether there is merit to that, to answer that question, and then we'd look at it, okay? For the California-based question, so this is important. There's one state where you incorporate, and that is the birth state of the company, okay? And so here we're talking about that's probably going to be Delaware. So a lot of times it's Delaware for many reasons, including, and not to say I told you so, but like the NVCA forums are based on Delaware law, or Series C, which are also another state. A lot of things are based in Delaware law, and investors like to see Delaware law and Delaware documents because they're comfortable with them, is one thing. Another thing is that Delaware's Chancery Court is a silly little court in Delaware that has like hundreds of years worth of case law and super investor and shareholder friendly mechanisms that allow, if there are any lawsuits, they go to that court. So instead of going to just a random court where you could have anybody as a juror or whatever, there are very specific business law courts in Delaware that help resolve business matters. That's another reason why Delaware is popular. Another is Delaware is relatively good at protecting your privacy of information. It's less easily ascertained, although it can probably be found in certain ways. But whereas like in Connecticut, where I physically live, you can go on the Secretary of State and pop up the person's home address most of the time of some of the shareholders or members, whereas Delaware, it's a little more private. So there's like a lot of different reasons we can get into why Delaware is often the state of choice. There's your birth state, which is the state where you start. And then also, if you're actively involved in your business in another state, you are required, there's a statutory requirement to register in those states or that state. So in your example, you'd be a Delaware C Corp that also registers in California, or most of the companies that we've worked with in Founder Institute are Delaware C Corps that are also registered in New York. So that's a whole specific definition of what that means. That doesn't just mean I have a potential client in a state, I might have a consultant in a state. It's a higher threshold, but it is like where you're actually working, where you're running the business, you probably should be in that state as a general rule of thumb. So it is a second state to be registered in. So, you've got your home state and you've got that state. I will say, generally, if someone was a New York or a Connecticut or Massachusetts person, they said, I want to just do a Connecticut C Corp or a Massachusetts or New York or whatever, because I know that's the state I'm going to be in and I only want to be in one state, That's a fair answer too. And if an investor someday says, I want you to convert to Delaware, we can do that 6, 12 months later, right? It's not, these things aren't incurable, but it's important to sort of understand the narrative of what you're saying. So that sort of maybe touches upon that. So there's a lot of different things, but all by way of saying, we're now talking about a lot of different things, which it's not just, hey, trust someone to tell you where to go, right? And
Could
so,
I ask a quick question, Jack?
yeah, of course.
So we're Delaware C Corp, originally home, headquartered though in Connecticut. Since we're moving to Virginia, what I just did last week, was relocated to a Delaware. I got one of those virtual office addresses, and relocated the headquarters to there, and it registered with Virginia, Revenue Department or whatever, to hire out of state remote workers and put myself on payroll for starting for when we move. So I'm registered with Virginia for employees working from home and for withholding, but I kept the headquarters as Delaware.
Great. So I have a couple immediate reactions to that. And this is a good moment for me to give my disclaimer of this presentation is not giving legal advice. I should have started with that one. I am not yet or ever maybe your lawyer. Please don't rely on this. Consult with your actual lawyer and or use Wiggin and Dana, and we can talk to you till the cows come home and give you real advice, right? And Sophie, you're next. I see your hand. Thank you for being polite and raising hands. So there's a few different things. So one is, so there's the Secretary of State, which is where you're actually registered. There's also the Department of Tax and Finance, Treasury Tax, right within a state. That's a separate state agency that you might be registered with. And there's also Department of Labor within each state. And so depending on the state and depending on the circumstance, you might be registered with DOL within a state specifically. And all these things are things you'd work through with your corporate lawyer and your employment lawyer on your team to talk to make sure everything's done properly as a general comment. And the other comment is, if you were a Delaware that's registered in Connecticut and then you left Connecticut and went to Virginia, you could resign your registration from Connecticut if you're no longer there anymore and you don't want to be in a state that you're not actually in, and you can apply to be in Virginia. So it can change right over time. Your home state of Delaware would stay the same, but you can go in and out of other states if you're actually going in and out of that. Like if you needed to register but then you don't need it anymore, you can remove it. It's not dissolving the company, but there's a whole host of things with that. Okay.
Sounds like we should have a conversation later.
Yeah, that sounds great. We can do our, office hours or initial consult or whatever whatever we want to call it. But yes, it all sounds good. Sophie, Patience Award. The floor is yours.
Thank you. I just keep my patience with the dead bodies. So we're just wondering, if we go the LLC route, can we still have like angel investors and early investors, or is that sideswiping that as an option?
Sure, great question. And Reed, just so you know, when I say 60 to 90 minutes, it's because of this amazing interactive format and engaged. This is awesome, right? This is what I want. Right? Yeah. This is what we want. This is what this whole thing is for. So thank you guys for breaking my rule of having questions. So in general, you could be, an LLC is a different option. An LLC is an interesting vehicle because, so there's your corporate entity and then there's the tax considerations for the entity. An LLC is a type of entity like a corporation is. An LLC could be taxed as a partnership. It could be taxed as a C Corp, or it could be taxed as an C Corp that takes an S election and becomes an S Corp. So an LLC could be, we're overly complicating here, but just so you understand, they could be a lot of different things. You could start as an LLC. You could be an LLC that then becomes a C Corp. The reason, and I didn't even talk about QSBS yet. So you absolutely could, if an angel or an early stage investor was so interested in your company that they want to invest as an LLC, it happens, right? It's not unheard of. The biggest reason why a lot of investors want to see a C Corp is because in order to qualify for qualified small business stock treatment, that's a thing where, based on several different criteria, if when you go and sell your company down the road, there's a huge tax benefit to the first up to $10 million that you take home. And so not only do founders want to see that, but investors want to see that, and it helps get a better ROI on their investment. And you can only get QSBS if you're a C Corp. And so a lot of times investors will say, look, I'll give you, $100,000, $500,000, but you need to convert to a C Corp. Then you could do that, right? You can use a couple of those $100,000 for the fees and the paperwork to convert. And so it's both the entity type, but also the tax treatment. So all by way of saying, like, you can change, right? LLCs convert to corporations all the time. If you are an LLC and you're going to convert to a C Corp, there is strategy behind when you might do it. And if you're an LLC that would be QSBS treatment eligible otherwise, you don't get credit for the time that you were an LLC. You don't get, like, if you convert, it starts at day one at conversion. You don't get credit for the year that you were an LLC. And it's a 5-year holding period for that to get QSBS treatment. So you start the clock the day you're a C Corp. So if you're going to sell in 5 years, maybe, then you need that 5-year holding period as a C Corp. Okay.
And I'm assuming, just to test for understanding, it gets harder to transform an LLC into a C Corp the longer the business exists, or is it a relatively simple process?
With the caveat that it would be best if everybody was Delaware C Corps to start. It's not that hard of a process to do. Yeah, and yeah, so.
Okay, last question, I promise. The office hours, that's free consultation, correct?
Yeah. I like to live by the rule, we're deviating from the syllabus here, that a good lawyer has communicated to a good client that the good client knows that they're going to start paying for stuff when that's going to happen. It's not a trick. The office hours are part of Founder Institute. It's not as, we are not acting as your legal counsel for those, so it's general advice like this. If you want to engage us, then that's separate, but also we talk about when you're on the clock for what and how much we are doing and all that stuff. It's very, very in advance talking about fee structure and all that kind of stuff. But yeah, those are free as not your lawyer.
Awesome, that makes sense. Thank you, Jack.
You're welcome. Okay, good. Well, let's keep going then. We'll go to the next slide. And thanks for, these are really good.
I have one more question, please.
Yeah, sure.
I have a C Corp. Can I create an LLC also with the same name that own a section of the C Corp?
So two different things there. The entity name is something that is a state by state thing. So if it's ABC Corp, there could theoretically be 50 different ABC Corps, one in each state. Or ABC Corp might have registered in all, like Coca-Cola is not available anywhere, right? Or whatever, but there's 50 different states that could have names. That's also going to be part of the trademark, the IP discussion in a minute. But so you could have an entity that's ABC Corp in California and then ABC LLC in Nevada, and they're not even necessarily affiliated, or they could be affiliated because you made them both. Right, and you could have wholly owned subsidiaries and parent companies and all these things. All that should be driven by tax structure and tax strategy as to why a certain entity should be on top or underneath another. But that's all a conversation you should have with your corporate and tax lawyer in terms of entity structuring. And if you wanted to set up subsidiary LLCs of your corporation to house to segregate risk, if you were doing different types of platforms and different type of project, this is overly complicated for this course, but you could do a number of different things. But again, don't just do them on your own, right? Have someone help you structure them. Okay, great. Okay, now let's keep going because I want to make sure we have time for everything. Okay, how do I protect myself from co-founder issues relating to equity and/or IP, which is short for intellectual property? So A is you can't, they are my co-founders. I need to trust them and focus on building the future and not worrying about issues that might not ever arise. B, be clear about who knows what and who owns what and why and who is putting what into the company. C is determine appropriate restrictive covenants and IP assignments for each founder. And D is consider equity vesting schedules, especially for founders getting sweat equity. Wow, loophole for Giovanni. It might not be applicable for everybody. And we're not talking about prenups today either. That's a different course. So
I don't expect on getting divorced, so.
That's amazing. Neither do I. Don't ask my wife what she thinks. I'm just being silly. No, I totally get it. Okay, I'll give you guys a minute on this one. Okay. So if a couple more answers trickle in, great. Otherwise, we'll keep going just because I do want to talk about each of these. This is a bar exam question. Okay, we are raising and passing the bar here. There are actually 3 very good answers in this one, and we've only selected 2 of them, which is okay. We got 2 of the 3 right ones. But B is also very important in terms of who owns what and who's putting what into the company and what it's valued at and what they're getting for in exchange. So nobody took A. A is clearly worded in the way that makes my head hurt, and you guys are smart and you've picked up on that. But I will tell you that A is real, and people all the time are like, I don't want to waste we got to do all this. Time is tight, money is tight. We can't worry about a buy sell provision if we disagree on something. It's our vision together. We're going to, right? Like, you need to have, provisions that work through potential issues, that not everything is going to be unanimously agreed, if not only for yourself, that should be a good enough reason, but also investors are going to want to make sure you have the structure that's built to deal with potential disagreement. You're going to disagree with a co-founder from time to time. So obviously we don't just run things on faith, so A is not great answer.
Technically C is invalid because covenants is misspelled.
Yeah, very good. Very good, Brian. So yeah, then so be clear about what and why, who's putting what in the company. So for B, I do think it's important when you're talking about setting up, okay, who's putting capital contributions in, who's going to do what, who's bringing intellectual property into the company, who's created the IP, who's an inventor on a provisional patent that then is going to assign that provisional patent to the company, right? So like there's a whole host of things when you talk about who's bringing what into the company. And so B is important and an important consideration. Right, restrictive covenants and IP assignments for each founder. So again, you want to make sure that each of you the company is protected and each of you is restricted in, what you can and can't do. You don't want one co-founder to just go and run and do things adverse to the company because it may have been that co-founder's idea, but now you have a disagreement and they run off and do stuff. So thank you guys. Good jokes. And D, so D is obviously super important. Equity vesting schedules, sounds like people are familiar with that. People took that as an answer, which is great. Especially for founders getting sweat equity, we put that here because, if there's a founder who's financing the whole thing, if someone's putting in $100,000, right, then the less concerned maybe about a vesting schedule for someone who's putting up cash, whereas someone, and this goes back to the example of, can we trust the co-founder to do all the things they say they're going to do, or an early stage employee or consultant to say, okay, having a vesting schedule over time or milestone based to show that they've earned what they're supposed to be getting. They're not just getting a chunk of equity and then underperforming, right, is important to think about. And, sometimes it might be awkward to say, hey, so-and-so should have a different vesting schedule than the other person, but it's based on business realities, right? So, important to set up. So a lot of times that can be, and again, this is from the beginning, a key consideration, particularly with equity stuff, which we're going to talk about a little bit more. Okay. So next slide, please. And hopefully fewer typos on the next slide. Okay, what's the best way to deal with commercial contracts? So we get contracts questions all the time. So A, do them myself as much as I can, only asking a lawyer if I run into something I don't understand or if I run into an issue with an existing contract. Have a lawyer draft a form contract for my customers, another for my vendors, another for municipal or government grants, and another for situations that arise. search online myself and find forms that I think make sense and then ask a lawyer to review them. D, have initial discussion with the lawyer on next steps, who to contract with, efficient ways to create forms, review contracts and contract provisions. All right, they're trickling in. So I will say, so thank you for the one person who put the first one. Even though that's not what I would advise, 8, 9 out of 10 founders that I work with want to try to do as much as they can on their own. You know, either just thinking they understand, they have enough that they think they know, they don't have questions, they're just going to sign a contract, or draft them themselves. Obviously you don't know what you don't know. It's worth spending a half an hour to have a lawyer look at a contract and say, yeah, no, there's no material risks based on what you're doing. Yeah, ChatGPT, another one, right? So I know it's done, right? You just have no idea what you're getting yourself into. It's worth, you know, asking a professional to make sure to vet a form, you know, is obviously the best case scenario. I'm interesting. So in the past, a lot of people put B here, which is my trick answer, but you guys are smarter than the other groups I work with. So this is the overkill box, which is a lot of people are like, hey, I might need 8 different types of contracts at some point, and I should draft them all now. Well, you don't actually necessarily need all the contracts until you actually need them. A lot of times, if you have a client or customer contract where it's a big client or customer, they're going to want to use their form of paper, right? And so it's sort of a David versus Goliath thing. So we try not to draft forms of agreements unless and until it's very probable that someone's going to ask you for your form of agreement and it's advantageous to do so. So that's a little bit of like a strategic point. This is me, the lawyer, saying more is not necessarily better in this case. So like if someone said, I need 10 different types of contracts, I would say, let's start with 1 or 2, and see what you really need in the short term. And again, a good startup lawyer will be sensitive to what you really need and your costs and your runway and all these things. And so it's not just like do everything all the time. But D is the right answer here, and you guys all did great with that. So to Brian's question, as we go to the next one, thank you, Sham. So it depends, Brian. Like, there's no pride of authorship here. So like, I'm not saying you must use our form because we are God and you are human, right? And God is all omnipotent and created the earth and all these things. If you have a form that you pulled somewhere and you share it with your lawyer and say, hey, I got this from, you know, one of these sources that, you know, that creates, you know, templates, you know, like Atlas, or like Stripe, then it's possible that it might be a decent form. Nothing would make me happier as your lawyer than to say, yeah, actually good. I don't need to spend 2 hours with you on this. I don't need to bill you. You don't have to pay it. This one's good. Go for it. Right. That's easy. That's a good answer. It's not always the right answer. So like, but ask, you know, but it's certainly, it's a pleasant surprise when something is close enough or good to just go. And that's not a negative. So I would just say always ask, right? Okay, what's a good way to attract key personnel to help me build and grow my business? 1, create restricted equity incentive plans with various forms of equity, restricted stock, ISOs, non-quals. 2, when budgeting cash flow and determining how much to raise from investors, err on the side of a higher budget to ensure reserves to pay personnel. C, try to hire people as independent consultants and contractors as much as possible. And if I really need to hire, try to make them as at-will employees. D is consider certain compensation structures based on completion of projects rather than time worked, and consider blended compensation, cash and equity blends. Good, really good. So these are all good answers, and everyone Yeah, well, no, that's why it's the bar exam. You just have to pick the best one, even though all four of them are good, and the bar exam sucks, and you know it's a terrible, terrible thing that takes years off your life, right? Sorry for saying a bad word. So yeah, no, this is good, right? And I'm glad people didn't see that they were going one way and everybody picked something. These are all good answers. You know, equity plans super critical for early stage attracting personnel that want to work at startups. You know, the expectation is still the hope to get equity in an early stage company, and the cachet is still there. You know, um, B, I do want to touch upon, which is people are always saying, I think that there's a tendency to not want to ask for too much money. The right answer in fundraising is to find the number that you actually need to do all the things and get all the people that you actually need, and then go do it and show and tell why. But don't skimp. Don't then turn around 3 months later and be like, oh, wait, I'm out of money. Right? Build it out the way you want it to be built out. So asking for enough money to do so is the right answer. So C is good, with the caveat of super important to make sure consultants, if you're calling them consultants, that they actually are consultants, and you're not just calling them that because they want to be called that or because you want to call them that. The Department of Labor and the IRS don't care what you call them; they care what they actually are, and that's a legal thing. So the worst thing you can do is call someone an independent contractor, even though they work full time for you, and maybe they have a non-solicit, and you know they're in your office every day using your computer and all these things that are definitely making them employees. Control is a key feature of whether they're an employee or a consultant. If someone's actually an employee, but you're treating them as a consultant, you will get fines and penalties and issues if you're ever reviewed by tax or labor departments. So please, please, please make sure to do that. And I will just one plug, because I have a client that's still dealing with this and calls me every month to say, you were right, I was wrong, I'm sorry. And I say, you don't have to say you're sorry, but I do appreciate that I was right part. You know, they had this star person that they thought was what they really, really needed, because she interviewed really well. And she said, I'm only going to work for you if you give me, you know, 3 months severance and a full employment agreement. And they were like, we're desperate. And I was like, if it doesn't work out, this is going to kill you. Like you don't have the bandwidth to do this. And I'll talk to your question in a minute, Sophie. Sure enough, they rue the day that they're sitting there. They're like, we would fire her if she was at will, but we don't want to pay her the 3 month severance, and it's not enough to terminate her for cause. She's not burning the building down. You know, she's not, she's not stealing anything. And they're saddled with this person. You know, that the term's about to finally end, but you know, this can really derail things for an early stage company. And the milestone stuff, I mean, again, you can do all sorts of vesting schedules for your equity, but the idea that you might have someone who gets equity based on achievement of a milestone, right, is very beneficial to a startup when you're results driven, right? So that can be valuable to you as well. Sophie, what if they're full-time elsewhere but doing some projects for you? Well, if they're full-time elsewhere, they probably shouldn't be doing projects for you, but different discussion. For the purposes of you, yeah, if someone is very part-time, doing their own thing on their own time with their own, whatever, and every once in a while doing stuff for you, they are, I would say definitely a consultant, but almost definitely a consultant. You want to work with your team to make sure that that's right for 5 minutes. But yeah, that's usually the answer. Yeah.
Just to add like an example to that, in my development, like fundraising development work, a lot of people had our full-time job, but then would do side consulting gigs, and that was allowed legally. So that's kind of what I'm thinking in this industry.
Right. So the separate avenue, which is more interesting, is, are they allowed to do it at their full-time job? Right.
Yeah.
And, there are restrictive covenants, that they might be under that you might not know. And then say they work for Google, right? And Google then hears that they're working for you, which they're not supposed to do. Not only do they get mad at them, Google gets mad at you. So as much as it's their business, not your business, it kind of is your business. And so you want to be careful with that on the restrictive covenants, especially if it's a big institutional company. Okay. You're welcome, Jane. And the rest will be recorded. And you're welcome, Sophie. All right, good.
I just wanted to add on that point, although that is generally true. You do have to be careful. There's some classifications of part-time employees that must be considered, part-time workers that must be considered employees, and it's also state by state. So it's great. I mean, Jack's obviously totally right, but it is this weird little area that you can get tripped up on, and it's a pain.
Yeah, no, very good, Sham. I am very much oversimplifying as fast as I can in 60 minutes or less. But right, so and to Sham's point, which is a very, very good one, Sophie, the answer is we call our employment law person and we say, she's got this person in this state that's doing this, is this okay? And they say yes, and then we're good. Okay. All right, good, let's keep going. Okay, what's the best way to handle IP matters for a startup? Ensure that the corporate team I create mirrors the branding I pursue, as I may not need to secure trademark as the name is protected. So in the version of William's question, my company is called ABC Corp, so I don't need to get a trademark for ABC because that's my company name, is the idea for A. B, enter into an NDA, which will always protect me and my IP, whether trademark, patent, trade secret, or otherwise. C, wait until branding is launched to seek trademark registration or until my patented invention is finalized before investing in a patent application. Or D, start developing now and worry about it later. Wow. These are getting tricky. I have a terrible poker face. I don't play poker anymore. All right, so we've got 5. This is a very, very hard one. And it's hard. We got 7, so I'll just jump in. It's hard because probably none of these are great. Okay. Again, don't take the bar. It's not fun. So first of all, A is just not accurate. So you have your entity name, and then you have intellectual property rights and trademarking and branding and all the things that you would market all your name or your products and all these things under. They are different things. Just because your corporate name is one doesn't give you any real trademark protection. If you are trying to market your branding and protect your branding, then you do want to go through a trademark analysis. 2 is maybe the closest to right. An NDA is something that you should have definitely and will give you some level of protection, whether because you could actually, get injunctive relief and a preliminary injunction against somebody if they were to breach an NDA. Maybe just because you have an NDA, they think, oh, I shouldn't breach this NDA, which is maybe more likely. NDAs are tough. You still want to make sure if you're really giving away the secret sauce, you want to make sure you really have a level of trust even under an NDA, because they are hard to enforce. And also, and again, this is like doomsday, but once the cat's out of the bag, it's hard to bring it back. Or I guess horse out of the barn is better than cats out of the bag. But once an animal is out of a place, it's hard to bring that animal back into the place. In other words, if someone breaches an NDA and your darling idea is now out there, yes, you could try to sue them for millions of dollars, but what you really want is your idea to not be out there. And it's very challenging to get it back once it's out. C, look, there's intent to use trademark applications versus used in commerce. It can just be an idea and you can file for trademark protection and it goes all the way back to the date of your first filing. Even if you're not using it, you have plenty of time to use it in commerce eventually when you do a trademark application, if you know it's something you want to do, but you're not ready yet. And same thing, you can, filing provision, there's a whole strategy behind provisional patents versus full patents. You'd work with your patent and trademark lawyers. We have both if you work with us, on the strategy of when and how to do these things and how much it costs and timing and, strength and all these things. But it's not just wait till it's actually ready. You might be able to do things on the earlier side. And D, I love that 3 people said it. I mean, maybe start developing now for a little bit. But don't wait too long, and definitely don't close your eyes and cross your fingers. That's not a great legal strategy for the picture there. The whole point here is IP counsel, startup-based IP counsel is super important to work with and collaborate with when your IP is so critical for so many of you, for so many startups. Once it goes wrong, it's wrong. It goes bad, it's bad. Being really careful about your IP from the beginning and having an IP strategy with your startup is super important. So that's the takeaway for this one.
I have a personal anecdote on that one that maybe I should, maybe I shouldn't share.
I don't know if I have a mute button on you, but you can start if you'd like.
So I started launching my concept actually 10 years ago as just a hobby on the side, and I got a few customers, and it was just naturally organically growing. I wasn't marketing or anything like that. At some point I realized that there may be something patentable about a business process patent or something. It wasn't a product patent, but I thought there was some opportunity to get some patents. And I went to a patent and trademark attorney, and they gave me the very unfortunate news that once I had sold the product to the first customer, I couldn't actually file.
Okay. So sorry. So, and what you sold? What exactly did you sell?
Once I had sold the first product on the market, like I had put the product with the business process code in use, and I had that sold, and I had my first paying customer.
Oh, from a patent side?
Yeah.
Because it's no longer like, I don't know, whatever patent people say, like novel or secret
Yeah.
or whatever. Yeah, right. I don't speak patent. I speak English with patent lawyers who understand. Right, yeah. So perfect example, right? You don't know what you don't know, and then all of a sudden it's too late, and what a pain in the neck that is, and how frustrating that is, right? So,
Yep.
if you have patent questions, you go straight to our patent, you pass go, and you go straight to our patent people, and you work with them directly, because that's, like you said, super important.
So that's an argument against the third or
Four.
letter D.
Yeah,
yeah.
Yeah, I mean, I there's lots of reasons not to do D, but look, in your beginning of working with startup lawyers, you want to be working with IP counsel on day one as well.
Yeah.
Right, for sure. So, but thank you and I'm sorry about your anecdote, and it wasn't like so personal that I had to mute you, but thank you for sharing. Great, let's keep rolling. I think there's just a couple more here. How important is it to work with my lawyer about tax matters for startups? More important to work with my accountant if I have one than my lawyer. Not too relevant for an early stage company. There's not a lot of money at stake. My company's valuation is low, and we can address it or fix it later. Tax aspects may be the most important legal consideration for startups. All right, so are there any accountants here? Yell if you are. Okay. Anybody have parents or siblings or loved ones who are accountants? Okay, good.
I've just spent, a year working for a big accounting firm, but I don't think
Right. Okay. So I'll tread lightly. In the business startup world, accountants are more reactive and file returns and help with the math on plans that are given to them typically, whereas tax lawyers are typically more proactive and strategic, and we work together. So my tax partner and I and the accountant will all get on a call and we'll all work through it together. But the idea of how you're going to structure things and create things, whether it's qualified small business stock treatment, we talked about that already, whether it's doing restricted equity with 83B elections and making sure but the accountant will file the 83B election to make sure that you get if anyone, we can talk about what that means if you guys need to. It's the lawyers that'll help structure your restricted equity agreements and make sure that you're using tools that will avail you of 83B election and treatment. So most transactions have tax consequences involved with them, and a tax lawyer is very, okay, great. So I'm glad we don't typically file them, but we would explain them to you, right? Yeah, but so it's good to know that Stripe does that too. And if they mess them up, I guess you sue them, right? I don't know.
They do provide you the proof of filing, and
Right.
then you send that to the accountant. That's what I did.
Yeah, right. So in any case, we have a company that just started working with that meant to paper something as a loan for 1% of the company, that meant to paper a $15,000 loan to the company as a loan, but accidentally put it in their operating agreement and gave the person 1% of the company, which suddenly creates a weird value situation for what the company is valued at. If 1% is worth $15,000, you can do the math on what the other 99% is worth for these startups, for these founders who just created a company. And once you have, like, you can, I guess, like, lie and, rip things up and pretend you didn't do it, which don't do, right? That's fraudulent, and we're not recommending. Even I can even say that as not your lawyer. Doing stuff right from the beginning is super important. Making sure that you don't do something to inadvertently trip up tax issues is super important. You can very quickly have tax problems from the outset. If you miss the 30-day window on the 83B election, it's not something that has a cure period. You use it or lose it. There's so many things that are tax driven that are super important for startups. So again, there are people that can help you file them, and then there's people that can help you think about them and make sure you're coming up with the right ideas at the right time. So I actually think the tax stuff is a lot of times the most important, has huge business implications, financial implications, and stuff that you can't just change and fix later. If you have an operating agreement and you want to change a provision and it's just two of you, you can pretty much do that most of the time. But like a lot of this tax driven stuff is really hard to walk back from if you make mistakes. So, and I don't think many of the filing companies give tax advice or claim they do, because if they did, they'd get sued. But in any case. All right, let's do the next one. Great, and I think this is the last one, and I'm sorry that we've gone a little bit over, but hopefully fun and interactive. So when raising money from outside investors, which of the following statements is least problematic? The least problematic is definitely a bar exam type question. When, this is really small. When mostly fundraising for friends and family, I don't need to worry about SEC compliance for general solicitation, accredited investors, etc. Hey, it's just friends and family. It's not a big deal. You can infer from my tone how I feel about that. I can broker different terms for different investors and purchase agreements and or side letters and not disclose to other investors. Material disclosures about my company aren't important. Disclosure memoranda are rarely read, and risk factors in offering documents scare investors. I can use my business plan and investor email updates as my sales pitches, since my offering disclosure docs and risk factors are protective documentation. All right. So a very oversimplified comment on issuing equitable securities. Giving someone anything that could be deemed an investment contract per the Howey test, the only case that a corporate lawyer will ever cite, in my opinion, is a security. And so whether it's stock, whether it's options, whether it's warrants, whether it's convertible notes, whether it's safes, whether it's anything, an equitable security is subject to securities laws, and there's a whole host of things that you need to make sure you are doing correctly to not violate securities laws. Now, I'm not saying you're Bernie Madoff if you give friends and family some equity and don't do it properly. but also don't do that. And so anytime you're giving equity to anyone, you need to be really careful about what you're giving, how you're giving it, why you're giving it. So just because it's only $50,000 in angel checks, doesn't mean you just go fly off and do it on your own. Be careful, consult a lawyer. C, I'm glad nobody put that about disclosures and PPMs and risk factors not being important and scaring investors. The one thing I will say, as you get into equity rounds and you start offering, real risk factors, it's super, super important. It's super valuable. There are lawyers who sit on the other side of these things and wait for investors on deals that went wrong, and then they wait to see what the risk factors are. And if you didn't have the things you're supposed to have, you get sued. Now, granted, the company hadn't done great then, so you're in a tough spot to begin with. But there's a whole industry of making sure you do this stuff right. Be really, really careful. Work with a lawyer on that. The risk factors are for your protection. If you say, this might go wrong and it goes wrong, you've warned people generally, and that's a way to protect yourself. An additional limitation of liability. The B and D, so somebody said B, just got to be really careful on what type of investment it is, how you're disclosing it, how you're papering the transaction. Clearly there are side letters and agreements. There's things you can work through, but you got to be really careful, in how you do it, and what you disclose and how and when. And D, I do want to talk about for a minute, which is, an email, not to scare people, but an email to an investor with a quarterly update, right, is a written communication about the business and something that an investor could rely on. And so, even though you're going to have all these documents that say, hey, here's the offering documents, here's all the whatever, you don't want to just be flippant about your emails and be so cavalier that you're promising things, that your company's going to reinvent the question mark and all these things or whatever. You need to be careful, just because it's not in your offering documents and it's in a written email, you got to be really careful in what you write to investors and how. So, just not to scare you, but just you want to work with, understand what you're supposed to do, what you're not supposed to do. Very quick oversimplification, but the takeaway that I want you to have on this one is that not to do A. Don't just go raise money from friends and family and think that you just do it on a napkin or on whatever paper you found online. You should work with a lawyer before you take any money.
Jack, can I ask a question on this one?
Yeah, sure.
So on that last one on the investor updates, part of FI methodology and, and other people, we are not the only ones to recommend this, but, put together a list of investors that you want to reach out to and send them, we recommend monthly updates just to like, hey, this is what I'm doing. This is what I'm going to do in the next month. This is, what I'm planning on doing. We would, we suggest putting those together, not taking a huge amount of time. Are those things that need to be, sent before a lawyer before you can send those out?
So everybody hates lawyers who say it depends. So I will say it depends. Look, the general idea is to make sure people understand what they're doing. And so I would want all of my clients, if they're going to get into that world, to understand, sort of like I said, any shape or size question mark invention or, whatever. You don't want to you don't want to say stuff that's never going to happen, right? You don't want to mislead anybody. As a general rule of thumb, don't write emails that are misleading or potentially fraudulent, right? So that's a general comment. No, we don't need to fact check or review every single investor letter that goes out, but there should be a discussion. Maybe we look at the first one or talk to the client about, hey, this is how you're going to do it, stuff to say, stuff not to say. We can look at the first one and go, ooh, don't do that. And then you get a sense of it. Certainly not, we're not trying to babysit every single thing. We're trying to teach. So it's like a case of first impression. We usually look at them for people.
So the question here was, which one of these is the least problematic?
Mhm.
Would the friends and family fundraising not be the least problematic? I understand it still can be a problem because the other ones open you up to extreme liability, or compliance issues, or just other laws. The friends and family, it's more you might have some tax implications or equity issues if things aren't done properly. In terms of a risk, the others sound worse in how bad things could go. Or am I missing something?
I mean, the short answer is these are all bad, and it was a trick question. But I appreciate your deep analysis of how to answer them. I actually think there's more wrong with the friends and family one. It depends how you define friends and family. I'm not necessarily talking about just your uncle and your best friend from college. I mean, people use friends and family to describe much broader, almost general solicitation, 506C type offerings. And so, look, the issue is then a seed round investor comes in and goes, what the hell did you do, right, with your friends and family? And there's huge risk of you've messed it up from the beginning, and I'm not going to invest in your company, right? That's the risk, the bigger risk in A, although there's multiple risks. I would say B could be less wrong if you were really careful with how you structure your investment and your side letters and your disclosures. There's ways to be pragmatic about it. So maybe it's B. Again, these are all not great. C, nobody picks, so I'm not even gonna talk about it. And D, so you can use your business plan and your investor email updates as your sales pitches and be salesy, just not too much so. Just want to make sure people understand that those are written disseminations to investors that can be relied upon. So you got to be careful with them. So D is like be careful, but there's ways to do it that could be okay, if that makes sense.
Yeah, thank you.
But anyway, so that was longer than I had promised. I think that's everything. Sean, were there any more, or is that everything? Yeah, great. Okay. So look, the goal here is hopefully you had fun. Hopefully you learned something. I thought engagement was good. You guys had good comments, good questions, good thoughts. The takeaway here is not to scare you. The takeaway is to be thoughtful about stuff that you might not have been thoughtful about before, and to realize that there are people who can be your advocates and help you know what to be careful about, because you might not, because you do what you do every day, and what we do every day is protect everybody on all these types of things. This is all we do. We don't create fun businesses. We just do, look out for people. So, I hopefully this was helpful. Again, super quick, super broad. But, and obviously any follow-up questions, I know some people have some. I'm happy to work through them as launching points in the office hours as we get to know you guys. So thank you I'll be quiet, read as a comment, but thank you guys for all doing this.
Well, I have one last question for you. I want to hit just be super direct. I think a large part of this whole discussion has already been trying to answer it, but I want the short, pithy summary answer for you. So one of the things our founders have to do to graduate is, incorporate a C Corp. We don't talk about the details there, but we have reasons for why we need it, whether or not, and why we think it's good for most of the founders coming through our program. But so they incorporate it as a C Corp. You offer a good package that we've helped, put together for you. But they can also go to someone like Stripe, Atlas, and get an incorporation. And many founders say, let me do this cheap now, and when I need more real legal advice, I will go and talk to Jack at Wiggin then. What's the answer for why they should come with you now?
Sure. So I'll be a little cavalier. I hope I don't rub anyone the wrong way. Our package that we do for you guys, if you want it, is not our biggest moneymaker in the world. We are doing it to make sure you have the peace of mind that you can ask 100 questions about all the things that you don't know about, and we can give you the answers for a very, very small, package price. And also to make sure that there aren't the things that are done wrong. So like they forget to have there's so many different platforms that do so many different things, and half the time they don't include the restriction on transfers in the bylaws, or they don't have a shareholders agreement if there's 2 or more founders, or they don't have, a handful of things, or they don't really do restricted stock grants properly, or, like you said, they could do the 83B election, but does somebody forget it or whatever? Is there, look, the limitation of liability for directors in the certificate of incorporation, can you cure that by doing an amendment a month later? Yeah, of course, but it's just another filing fee, right? So the idea of doing it right the first time is better for you. And like when you do use those platforms, you can get stuff. It may be right. Hopefully it is. With us, I don't know, I can guarantee, I mean, it's right. And you can get explanations and educations, not free education because you pay a little bit for it, but it's the education and that you're buying as well. And all that being said, I'm not offended if people want to use those sets and then come to us for the next stage of work like a week later or whatever. It's a business decision. It's whatever you want to do. We do see a lot of times there's stuff that was missed and then we have to add and help or whatever. But like, if you go form it on yourself, we can work with you after you do that. Like, it's all good, but I do think it's that first month of really knowing, you should incorporate ASAP. You should do it, whether you use us or somebody else, do it the right way. Immediately start talking about all the things we just talked about, right? Every single one of those. I don't know that Atlas gives you this lecture or like all these topics, so that's, I guess, not that short of an answer, but
I'll just add, there's another person from our firm who's involved, Len, and so I've just heard Len say it so many times. I'll just throw it out here. You're welcome to use Stripe Atlas, pluses and minuses of these companies. He always asks you not to use LegalZoom.
yeah.
So that's his one thing that he begs you not to do. He thinks those forums are terrible, and they're not great.
They're terrible. They are absolutely terrible. We can all be anti-LegalZoom, and if you like LegalZoom, then I'm sorry that I've offended you after an hour and a half of having fun.
So I'll also say, you might have heard
ChatGPT or
this.
LegalZoom?
What's that?
What's worse, ChatGPT or LegalZoom?
Oh my God. I mean, ChatGPT, it's just, I can't.
So I will say, I think Jack and Sham, you guys have probably heard me say it before, but years ago, before my time at Founder Institute, we used to, we had a partnership with LegalZoom. We're a Silicon Valley company. They're like a, Silicon Valley, startup kind of thing doing this. And it seemed like a natural fit to really like streamline, get, again, before my time, so don't fully know the details, and things have changed for sure. But my understanding was so many things came out so wrong that partnership did not last very long at all. And that is why we have pivoted to working with people like Wiggin to make sure we do these things. So it scarred us for a long time.
Thank you for sharing, and I'm glad it was before your time because I know you're perfect, Reed, so that makes sense on that timeline.
Yeah.
The one thing I'll say, so like we do a questionnaire, which is where we get all the information of all the stuff that you want to do, and then we look at it, and 9 times out of 10, we have at least one follow-up question or comment that maybe you didn't fully get it or think about it exactly the way we were thinking about it, and we want to have a further conversation before we then do all the documents. Those platforms will take your responses and spit them into documents, right? And so I do see when like maybe you didn't fully understand the concept of a tag along or a drag along or whatever, right? We don't just spit the documents out. Like we have multiple conversations to work through explaining everything that you get. So I do think that is an important inflection point. Like it's the discussions are of what the terms are and why and how and what you might want is as much of any of this as the rest of it. So anyway, I'm not even gonna say I'm on a soapbox because I've got bigger things to soapbox about. So
okay, I'm going to say thank you, Jack. Thank you, Sham. thank you, founders, for coming in on a Monday. We put the email up there in the chat. I'll also be shooting it out again, but for, scheduling office hours with these guys, recommend, starting early. We're going to see them come in again. I think it's week 9. It's on your schedule. I'm forgetting my dates. I've been doing this long enough, I shouldn't, but they'll come back and there'll be another time like as we're incorporating, but I recommend, beat the rush, schedule some time with them now and start thinking about these things. Yeah, otherwise, and that'll also be, a chance to kind of ask some more of your specific types of questions.
Yeah.
And then just before people start completely dropping off, I promised also that if anyone wants to do some pitch practices, run their 60-second pitch by me, get some feedback on it. I can stick around for a while longer to do that. But I know we're, only if you want to, only if there's people who have interest. And otherwise, thanks, Jack. Thanks, Sean.
Thanks, guys. Thank you for doing it. Last thing I'll say, last thing, we can give a lot of free, not necessarily legal advice in office hours and an initial consultation of questions you have. That's a thing. What we cannot do is help you with questions that you never reach out and ask about. So those will just go off into the ether. So the worst thing you could do is take a free 20 minutes to ask us a handful of questions, and we can go as far as we can go before we engage. So, happy to help out in any way we can. We're here for you guys. So,
Reed, I don't see Jack's info in the office hours booking piece online.
Yeah, and you'll see this for some other mentors as well. Brian, I know we have, but I put they have an email address and they preferred you just to email and schedule time with them that way. So I put it up in the chat. I will put it again in the chat and we'll send an email out. But
the trick is if you write it in Pig Latin, it'll get sent to me.
Oh, I was on mute. So sorry.
If you have if you have something where it's like, hey, Jack mentioned this, I'd love to chat with him based on a follow-up of something he said, just put that in your email and we'll,
okay.
It will get to all of us. So it'll get to all 3 of us by sending it to that email. So it's just an easier way for us to collect.
Yeah. Figure, and that way also you don't have to go through the whole thing. I'm in the Founder Institute spring, we'll know that hopefully.
Exactly.
But do give a little bit of context, on who you are and what you're doing, which is good for any mentor you write to, right? Is always start with a little bit of hey, this is me. This is, one sentence about my company, which we've all taught you how to do, and this is why I'm writing to you.
All righty. Well, now you know where to find us. And great seeing you guys again. Thanks for being here. This was fun. Hope you enjoyed it.
Thank you. I have a 1-year-old I have to go home and put to bed.
Okay. Nice. That's why I said don't ask about my wife, because I was supposed to put my 3-year-old to bed and I'm still in my office. So whoops. Beg for forgiveness. All right, guys. Good to see you. Thank you.
Thanks.
All right,
Bye.
Bye.
Reed, I was going to stay on for a quick minute. Just ask.
Yeah, you bet. Yeah.
I think.
Hold on one quick second. Let me just now stop recording.